In the last lecture, we started with the introduction to the cyber laws in India. As part of the cyber laws, we have seen what is the need of these uh, cyber laws, and the cyber laws can be fixed on the basis of which act that we have seen, and what are the supporting acts that are available in the India that also we have seen. So especially these cyber laws are based upon the Information Technology Act 2000 and Information Technology Act amended in 2008. And also these are supported by the IPC. At the same time, the Bankers Book Evidence Act and other other evidence acts, like especially like digital related acts, and also the acts such as the Indian Evidence Act 1872 is also modified to support these cyber laws. Today, we'll see the concept of Information Technology Act and its amendment so that we can gain the understanding of how these particular acts were structured and how the penetration tester or an ethical hacker, or if any hacking activity was done to with a malicious intent and damages any computer or reputation or any network, then what are the consequences that the hacker has to face? So these are the things that will come under the cyber security or cyber laws. So as I told you, first of all, you should know the key terms such as cyber defamation, cyber stalking, cyber terrorism, data diddling, email bombing, pornography, sale of illegal articles, webjacking, web defacement. So these are the key terms which are going to be used in the description of the acts. So you are supposed to be aware of these key terms, what it means. So the glimpse of IT Act, it consisting of 13 chapters. Chapter 9, 11, and 12 alone are related to the cybercrime and cyberspace. So now what we do is we'll mainly focus on chapter 9, 11, and 12. So remaining and other chapters are introductory chapters, preliminary chapters, description of the terms they use, and the responsibility of the subscribers, responsibility of the service providers, and regulations, certifying authorities, electronic commerce, electronic signature certificates. So these are the various descriptions that I have provided in the IT Act. However, we are mainly concerned about the Chapter 9, 11, and 12 of the IT Act, which are related to the hacking and consequence of the hacking. So under this, first we'll see the sections which are under the Chapter 9, penalties compensation. So here section 43 to 45 that are related to the penalties and compensations, especially related to the offences and related penalty. Here section 43 related to damage to computer or computer system, etc. Here the damage may be a physical damage or maybe the damage through the hacking activity. So here physical damage here in the under this particular computer and computer system, even the CC cameras or any other electronic component that is linked to the computer will be included in this. So compensation not exceeding 1 crore rupee to the person so affected. Next is for section 43A, corporate body failure to protect the data. Here data will be collected by some corporate bodies, but if the data was leaked out or if the data privacy was not maintained by the organization, then this section under section 43A, the penalty can be imposed. If it is done by the if it is recognized by the country, then if the country government feels that this is of national security, then they may completely ban the corporate who fail to protect the data of the consumers or customers. Compensation not exceeding 5 crore rupees to the person so affected. Section 44A, which are related to the failure to furnish the document that was asked by the court or tribunal, then penalty not exceeding 1 lakh and 50,000 rupees for each such failures. Section 44B, failure to file any written or furnish any information, books or other documents within the time specified, then penalty not exceeding 5,000 rupees for every day during which such failure continues. Because during the process of the arguments, the court may ask the petitioner and the defender uh, uh, for any production of any electronic information or electronic evidences. So, in case of failure of producing any file or maintaining of any books or ledgers electronically, for that related punishments will be like this, which are defined under section 44A, 44B, 44C. That is failure to maintain under 44C, failure to maintain books of accounts or records. Next one is section 45, where no penalty has been separately provided. The compensation not exceeding 25,000 rupees. That means even after the ordering of the penalty by the court, if the intended victim is unable to receive within the time, then court may impose compensation not exceeding 25,000 rupees to the person affected by such a contravention, or a penalty not exceeding 25,000 rupees. So additional amount may be granted for as a compensation, as when the victim is unable to receive the amount within that specified time. Next is cyber crimes and cyber laws, which are related to the chapter 11, which is section 65 to 78. Here, under section 65, tampering with computer source documents. So here, tampering with computer source documents, it is nothing but tampering of the computer files which are available in the computer or database, or tampering the data, or any kind of thing which are related to tampering. Imprisonment up to 3 years, or with fine which may extend up to 2 lakh rupees, or both. This is the maximum penalty that can be imposed under section 65. Section 66, sending offensive messages through communication services. So then they can be booked under section 66. Imprisonment for a term which may extend to 3 years and with fine. That means writing an offensive message and particularly targeting a person, continuously sending an offensive messages, they can be booked under section 66. So it is how it is related to the hacking. Obviously, the hackers sometimes, once they compromise the emails, so they may send some abusive mails or offensive mails to some other person without knowing to the victim. So these kind of things may also be traced as a hacking activity, and also they may also book under the section 66 for sending the offensive message. But however, here victim also will become a real victim, even though he is not the one who really sent the offensive messages. Section 66B, actually there is a section 66A, but it was struck off by the Supreme Court in 2015 as by inspecting a public interest litigation filed by a girl in Mumbai. She was booked under the section 66A during 2012. She belongs to the Thane district, and she has kept a comment on the social media related to the death of the late Bal Thackeray. So she was arrested under the section 66A. Actually, they have gone for the public interest litigation and they went up to Supreme Court. And after listening to the arguments, the 66A of the IT Act is compromising the freedom of speech. So hence, after observing the merits and demerits of this 66A, along with the Constitution. In Supreme Court in 2015, it was struck off the 66A. So from that time onwards, Section 66A is not applicable. But majority of the cases like this, offensive messages and all, will be booked under Section 66. So even after Supreme Court judgment in 2015, several other cases in 2016 and 17 were also filed under 66A, which is completely illegal. Many of the police may not be aware of that 66A was struck off. But still today, if anyone is filed or booked under Section 66A for sending an offensive message, as like sending an offensive message, etc., this is completely illegal. They can be booked under the defamation cases or sending offensive messages via Section 66. So in 2016 also this kind of cases were evolved. In Uttar Pradesh also, one intermediate student has placed some message on the social media. Immediately the police were arrested that person, which is actually who is a minor, and but still they arrested the person. But finally they come to know that they have booked the person under 66A. Then again the Supreme Court became angry, and finally the minor student used to be made released from the jail because because he booked under the wrong case. So 66A, this is the history of 66A. 66A is currently now not in use, not in existence. So 66B is retains any stolen computer resources or communication devices. So then this kind of activity, this retains any stolen computer resource or communication. Is actually stolen means here it's a kind of a robbery kind of thing. Imprisonment for a term which may extend to 3 years, or with fine which may extend to rupees 1 lakh, or both. Section 66C, fraudulent use of electronic signature. That means it is like forgery kind of thing, forgery electronic signature. Then imprisonment for a term which may extend to 3 years, and shall also be liable to fine which may extend to rupees 1 lakh. Section 66D, cheats by personating by using computer resources. Imprisonment for a term which may extend up to 3 years, and shall be liable to fine which may extend to 1 lakh rupees, or both. So this is related to Section 66D, and Section 66E is publishing obscene images, which is also imprisonment up to 3 years and fine not exceeding 2 lakh rupees. This is very, very important. Cyber terrorism. Usually, the cyber terrorism is a case which you may find whenever you are making a terrorism related comments or terrorism related messages, or planning for terrorist activities on a country, which will be treated as regarded as a national security. Then this cyber terrorism case can be booked. So Section 66F, imprisonment which may extend to imprisonment for life. So life imprisonment is possible if they have booked under the if anyone booked under the Section 66F of the IT Act, which is called cyber terrorism. Section 67, publishes or transmit unwanted material. Imprisonment for a term which may extend to 3 years and 5 lakh rupees fine. And in the event of the second consequent, that means if they find second time doing the same thing, then the imprisonment is a description of a term which may extend to 5 years and with the fine of 10 lakh rupees. So this is the fine for the Section 66, Section 67, which is a very that means first they will give you a chance to correct yourself, If you find if anything was if the same mistake was repeated for the second time, then obviously the severe punishment will be given. Section 67A, publishers or transmits sexually explicit material. So this is a very serious crime. Imprisonment for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees. In the event of second time, then the imprisonment may go up to 7 years and with the fine of maximum of 10 lakh rupees. Section 67B, abusing children online. It is considered as a very serious crime and which may extend to 5 years the imprisonment and the fine may be of 10 lakh rupees, and they may be also they may not be booked under section 67B. They may also booked under the POSCO Act. So next is 67C, preservation of information by intermediary. So the intermediary may collect the data, but he may not submit the data to the corporate. But he always maintain himself. He will always maintain the data at himself at his level, and he may sell this particular data to outside. So in this kind of cases, the preservation of information by intermediary will come into the picture. Imprisonment of for a term may not exceed 3 years and shall be liable to fine. We will see the chapter offences, that is we have seen up to section 66, 68. Now we'll see the acts which are there in the IT Act related to the cyber laws and cyber security, especially the cyber laws for the cyber security. Section 70 to 74 are related to the cyber security things. That means here the consequence of hacking activity. Section 70, unauthorized access to protected system. That means password cracking, escalating the privileges, gaining the access to the system. If it was done by the hacker without having any permission, then unauthorized access to the protected system is offense, which can be booked under section 670 of IT Act. Imprisonment for the term which may extend to 10 years and shall be liable to the fine. Section 71, impersonation to the controller or the certifying authority for obtaining license or electronic signature certificate. That means by misrepresenting to the controller or the certifying authority, that means you might have misrepresented the license or electronic signature, or you might have, if a hacker might have stolen the electronic signatures of some other and they might have represented the electronic signature as himself, then imprisonment for a term which may extend to 2 years and the fine is of maximum not exceeding 1 lakh rupees or both. Section 72, breach of confidentiality and privacy. So this is also leaking of privacy by hacking a computer or hacking a network. Then imprisonment term which may extend to 2 years and fine of 1 lakh rupees or both. Section 72A, disclosure of information in breach of contract. So whenever a contract has been made between the hacker and the ethical hacker and the organization, whenever hacker or penetration tester during the process of doing security testing, they might have identified some defects or some problems in their network. Okay, that problems or the defects must be informed only to the contracting organization. If the penetration tester or hacker, ethical hacker, might have leaked this information other than the organization, then this section 72A will be applicable. That is disclosure of information in breach of contract. So they might have made a contract. That is obviously any penetration tester or ethical hacker, by making a contract with the organization, they used to perform the hacking activity. In the contract, obviously it will be there like that. If any limitations are there, then that must be informed only to the organization. If they might have breached this contract, then imprisonment for the term may be extended to 3 years, which will, with a fine, may extend up to 5 lakh rupees or both. Section 73 and 74, publishing false digital signature certificates. So this is a very serious crime, because nowadays any kind of signature, that means for verification, especially for verification and for non-repudiation activity, the government agencies used to issue a digital certificate. So if they are going to publish a false digital certificate, if the hacker is trying to publish a false digital certificate, if he was caught, then he will be booked under section 73 and 74 as publishing false digital signature certificates. So for this, imprisonment may extend up to 2 years and a fine of 1 lakh rupees or both. So these are the various cyber laws and cyber security things. So actually, in the section 72A, disclosure of information in breach of contract. So whenever the hacker or penetration tester come to know the limitations of the organizational network, if he might have leaked this to public domain, in the public domain, because of that, if the organizational network was really compromised, then he may be booked under, the hacker may be booked under section 72A plus any other section that will fall under the victim's thing, that is leaking of data security, or leaking of tampering of computer, or damaging of computers. So this one is tampering with computer sources documents, damage to the computer. So all these things can be booked under this particular activity. So that means sometimes one offense may lead to multiple offenses, and all other different sections may be booked under this particular offense. So that is the reason this is the core offense, and there may be some other consequences also there. So all other consequences may also fall under different sections, and those sections may be booked under that particular penetration tester or ethical hacker may be booked under those sections. So whatever is the maximum imprisonment is there, that much maximum imprisonment may be imposed by the court once they prove guilty. So this is what the cyber security sections, especially from section 72, 74, will come under the cyber security. So here the crimes, especially these crimes, can be broadly classified into 3 categories. One is crime against individual, another is crime against an organization, another is crime against the nation. So here, crime against individual. Crime against individual, first one is stalking. So this is said to be cyber stalking, sending abusive messages and all, which will fall under section 66 of IT Amendment Act 2008. Since IT Amendment Act is the inclusion of IT Act only, there is no change in the sections in the IT Amendment Act. Along with the sections which are available in IT Act 2000, some new things were added. So that is the reason, always which is recent we need to quote, okay, not the previous one. So section 66 of IT Amendment Act 2008, and which will be mapped to the IPCs, section 503 and 506 of IPC, section 499 and 500 of IPC. So this is the mapping. Next one is exploration or webjacking. So this webjacking is nothing but going through the web. Webjacking, here taking the control of a website forcefully by cracking the administrative privileges. This is called webjacking. So you may be running your own website, but the hacker might have captured the administrative privileges and might have escalated the privileges. Then it will come under the webjacking. So this webjacking will be can be filed under Section 65 of IT Amendment Act 2008. So that will be mapped to the Section 383 of Indian Penal Code. Cyber defamation. Section 66 of IT Amendment Act 2008, and which can be mapped to the Section 500 and 509 of IPC. These are the crimes against the individual. So what are the silent features of IT Amendment Act 2008? Whatever the sections that are available in IT Act 2000, same are available in IT Amendment Act also. But some modifications and more clarifications have been added in IT Amendment Act with some new linkages to the previous acts and modification of the previous acts. The silent features are like this. The term digital signature has been replaced with the electronic signature. Here, electronic signature means the signature that you may place with the light pen, or maybe a digital signature, maybe any other thing which was filed electronically. That is what is called the electronic signature means. A new section has been inserted to define communication device. By the time the IT Act 2000 was framed, in India there are no smartphones and there is no touch technology related phones. So at the time they used to have very normal phones, which are very 2G phones or first generation phones. So at the time there is no laptop or there is no palm top and this kind of things. So in IT Amendment Act 2008, they have given the definition to the communication devices to mean that cell phones, personal digital assistants, or combination of both, or any other device used to communicate, send, or transmit any text, video, audio, or image. That is what the modification made in the IT Act 2008 to define the communication device. A new section has been added to define cybercafe as any facility from where the access to the internet is offered by any person in the ordinary course of business to the member of the public. That means under the IT Act 2008, the cyber cafe, that means the internet centers are also added as an intermediary. Okay. A new definition has been inserted for intermediary. A provision has been added to section 81, which states that the provision of the act shall have overriding effect. The provision states that nothing contained in the act shall restrict any person from exercising any right conferred under Copyright Act 1957. So, because publishing the materials illegally, usually the Copyright Act is there. To support this Copyright Act electronically or digitally, this section 81 has been added in the IT Amendment Act 2008. A new section 10A has been inserted to affect the contract concluded electronically shall not be deemed to be unenforceable solely on the ground that electronic form or means was used. So even after ending of the contract also, you cannot force to make use of the electronic form or content. So previously this particular thing was there, that was removed by making the section 10A. The damages of rupees 1 crore prescribed under section 43, that is, what is section 43? Tampering of the data, tampering of computer, or damaging the computer. Of the earlier Act 2000, for damage to computer system, etc., has been deleted, and the relevant parts of the section have been substituted by the words he shall be liable to pay damages by way of compensation to the person so affected. That means a computer may be of 20 or 25,000 rupees. If the damage was happened, how can one pay 1 crore rupees? So that is the reason they have modified that to he shall be liable to pay damages by way of compensation. That means if it is the compensation of 25,000 rupees plus additional amount, some little additional amount may be added and may be compensated. So this is what the thing, idea of this. A new section 43A has been inserted to protect sensitive personal data or information processed, dealt or handled by a body corporate in a computer resource which such body corporate owns, controls or operates. If such body corporate is negligent in implementing and maintaining reasonable security practices and procedures and thereby causes wrongful loss or wrongful gain to any person, it shall be liable to pay damages by way of compensation to the person so affected. So it is just like in recently Volkswagen. Volkswagen is a company have is a producer of many cars. Usually, the Volkswagen car will be having the engine at the back side instead of having the engine at the front side. That is what the specialty of the Volkswagen. And to control this Volkswagen engine, there is a software developed, and that software will always will give you the information about the pollution level that the car produces. But what happened? The program was wrongly loaded, or maybe intentionally, maybe wrong. But it always give you a, green level of pollution emission. But actually, it is not going to do so. Whenever the pollution will be checked under the pollution control places or pollution control stations, so it is always showing there is more pollution is produced by the car, but the software they have provided is always showing that it is the pollution is under always control. So based on that, a person from Uttar Pradesh has filed a case in the National Green Tribunal, and after investigation, they found that they have intentionally placed the wrong software in that. So thereby, the National Green Tribunal has fined of 2,500 crores to pay to all the purchasers of the Volkswagen company cars in entire India. Now this particular case is under Supreme Court. We will see what will happen next. So this is what the thing wrongfully doing some manipulations, okay, by placing wrong software and using the wrong producing the wrong data. This will also fall under the section 43A. Section 66A to 66F has been added to section 66, prescribing punishment for offences such as absence electronic messages, transmissions, identity theft. But in this, remember, section 66A was not in force now. Okay, it was struck off by the Supreme Court in 2015. Next is section 67 of IT Act 2000 has been amended to reduce the term of imprisonment for punishment publishing or transmitting obscene material. That is from 3 years to 5 years, and increasing the fine from the 1 lakh to 5 lakhs. Section 67A to 67C has been inserted. Next one is in view of increasing threat of terrorism in the country, the new amendments include an amendment section 69 giving power to the states to issue directions for interception of monitoring, decryption of any information through any computer resource. Further, section 69A and B, two new sections grant power to the state to issue directions for blocking of public access of any information through any computer resource and to authorize to monitor and collect traffic data or information through any computer resource for cybersecurity. So earlier, center used to control, that is, central government used to control these things. Then in the IT Act 2008, Section 69 was added to deliberate these powers to the state governments. So the state governments, if they feel that some malicious activity or some cyber terrorism activity is going to happen in that state, they have right to monitor the traffic, especially like tapping the phone calls or observing the network traffic, or turning off the mobile towers, or monitoring the mobile calls. All these things can be done by the state under the section 69 of IT Amendment Act 2008. Earlier, whenever you want to know who is using which mobile network, you can directly go to any call center nearby or any dealer nearby, and you can come to know the information. But now it is not possible to know the details of any person. You must get a permission, or if you want to tap anything, you must get permission from the superintendent of police, SP of that particular district, and you are supposed to perform the tapping activity. So for this, at the state level, you need to have a DGP permission or the government permission for tapping. So usually this tapping activity is not deliberated to the private. Only the public, only government has to do this particular activity. So previously, it is very easy to get the information of any person directly by going to the dealer and they can get it. But it is not possible nowadays because of this purpose. So because of the IT Amendment Act, one need to take approval from the SP of the district to monitor the thing. For example, you want to trace out a person where he is based upon the cell phone signals. Then it is not possible at the dealer level, or it is not possible at the customer center level also. Even any company, any service provider cannot do this particular tracing unless until there is a written permission from the SP of the district. So this is because of the IT Act 2008. Okay, so because cyber terrorism and terrorism activities are becoming more and more, this particular amendment has been made, and the deliberation of powers for monitoring the traffic was given to the state. So the reason in every state there is an intelligence bureau and also the vigilance department. So they used to do this particular task. Section 79 of Act, which exempted from intermediaries, has been modified to effect an intermediary shall not be liable for any third party information, data, or communication link made available or hosted by him, or if the function of the intermediary is limited to providing access to the communication system over which information made available by third parties is transmitted or temporarily stored or hosted. So intermediaries are only should act as facilitator, but not act as storage of the data. Okay, the intermediary does not initiate the transmission or select the receiver of the transmission, and select or modify the information contained in the transmission. As the transmission of the data is coming, or as the transmission of the signals are coming, he should not store it, he should not tamper it, he should not do it. He has to divert it. That's all. This is the only the intermediary's responsibility. The intermediary observes due diligence while discharging his duties. So it is just like a broadband provider is there, and there may be a dealer in your nearby. He is only responsible for getting the broadband connectivity and sending the broadband connectivity to the customer. Okay, he has no authority to trace the network which is passing through the providers or the intermediaries servers. So it is just like that. So crime against property. Previously, we have seen crime against individual. Now we'll see crime against property, since we have discussed the IT Act 2008. So identity theft, which will fall under the IT Amendment Act 2008, Section 66C. for which IPC supporting are 417A, 420. Like that, email spoofing, hacking, data diddling, salami attack, viral or worm attack, email bombing, cyber fraud, logic bomb, financial crime, denial of service attack, forgery. So we'll see in detail what are these attacks are and what are the related sections, because all these attacks will fall under the hacking. So whenever this particular thing was found, what are the punishments and all under the IT Amendment Act 2008 in the next lecture.